This episode of AHLA's Speaking of Health Law is brought to you by AHLA members and donors like you. For more information, visit AmericanHealthLaw.org.
Welcome, everyone. This is Rob Gerberry. I'm the Chief Legal Officer of Summa Health, the President-elect designate of the American Health Law Association. I'd like to welcome you to the latest in our continuing series of podcasts on corporate governance issues affecting healthcare organizations. Today's topic is designed to coincide with the autumn board meeting calendar, in which many of our members will be called upon to provide a governance update for board and committee members. In that regard, several emerging governance concerns are positioned for center stage prominence on upcoming agendas. These extend beyond the usual operational and financial script lines to include those with unique social, ethical, economic, and geopolitical impact. Some are big picture in scope, while others are more immediate in interest. Collectively, these are topics that board members as well as management will want to be made more aware of. As the leading governance advisor to the board, the general counsel, likely teaming up with the chief governance officer, is well situated to brief the board on these topics and their impact on the board agenda. As always, we're joined by my AHLA colleague and friend, Michael Peregrine of McDermott, who is also an AHLA fellow and a fellow of the American College of Governance Counsel. So, Michael, what tells me that you have exactly 10 emerging topics in your pocket to share with our audience today?
Well, Rob, you've hung around me long enough to know that in Michael world, there's only room for 10 of anything, not 9, not 11, but 10. But to show that I'm flexible as a matter of nature, I'm going to add some honorable mention topics as a special gift for you. So we'll probably go a little about 12 today. We'll see if we get to them.
Excellent. So let's start off with something a lot of us in the chief legal officer position have been hearing about: directors being worn out by all the demands of their board service, combined with the rapid changes that are impacting our industry. Is that on your list today?
It certainly is, Rob. It's number one, and we call it director fatigue. For many years, we've been, those of us in the governance area have been asked by clients, can we get rid of term limits? How can we focus on keeping directors, allowing them to serve longer terms? Now it's kind of the opposite. The emerging governance challenge doesn't seem to be how many terms we can get directors to serve. It's rather getting them to serve the full length of their first term before they bail. Board leadership is increasingly being called to address director retention challenges. We're getting signs that board members are becoming exhausted by their fiduciary workload. I think there was an article in Fortune about this a month or two ago. The fatigue seems to be coming from a byproduct of service on multiple boards, very complex board agenda, extremely detailed briefing books, greater third-party scrutiny, and then I think dealing with the constant social, financial, and political change. So I think item number one on my list is to encourage the board to consider credible solutions to what could be an acute problem of directors just getting worn out. And we really can't afford to lose good directors at this point in time with all the changes facing the industry.
So, Michael, is one of the factors that you see creating director fatigue, that being a board level information overload?
Oh, totally. Absolutely. It has to be. And we know that because we produce a lot of the documents that go to the board. I think that it's that proverbial drinking from the fire hose problem. In other words, the amount of information needed to brief board members is just simply overwhelming their capacity for preparedness. That, when they're getting too much to read and preventing them from being prepared for board meetings, that's a threat to effective governance. There's just so much that they need to know, both about what's going on internally within the organization, and I think now, especially what's going on externally, that many directors are having a hard time keeping up. And this is kind of separate and distinct, but still part and parcel of the fatigue. It's just that there is so much information they're being asked to read and keep up with. I do believe much of it is in the last year or so with events. We have to be thinking about solutions, and they can be found in changes how information to share with the board is identified, formatted. I'm a big one-page Ronald Reagan memo type person, edited and made available at the time of information delivery. How do we package information to the board? What works for them? And how do we send it to them? How do we timely make it available to them? And then another solution is also more effective use of committees with board delegated powers. But let me be clear on this one, Rob, and be very serious. Fewer board meetings isn't the answer, because that just simply means consolidating more information, crunching more information into a more confined period. We need to find an answer to information overflow.
I can tell you from my board that met 19 times over the last year as part of our sale transaction, there's definitely information overload that we're providing to them. So, Michael, we've talked before on this podcast about the need for civility in the boardroom. Just yesterday, two of my law students asked me, does respectful discourse still occur? Are you seeing that as part of your top 10?
Well, it's still you bet. It's number 3 because civility in the boardroom isn't a new issue, as you say. It is an ongoing concern. And so there's an offshoot on my list of civility. I call it perspectives tolerance. In the context of a crowded board agenda and pressure on the board, the chair is going to be challenged to maintain a boardroom culture that supports a couple of things: independence of mind, contrary views, allowing all director voices to be heard, encouraging a culture that encourages the freedom to constructively express contrary views. In other words, I'm not going to be called an idiot by a board member because I raise something that comes out of left field, and protects against bullying and disrespectful conduct. There are a variety of issues here, but again, tolerance of different perspectives. I'm just hearing from clients far too many situations in which there's an effort, and it can come from a variety of sources, to seek conformity amongst board members as to perspective, and to force out those board members who have different views. In other words, the concern is, at the chair's perspective, are we somehow intentionally or unintentionally seeking out board members who come from a single point of view? Are we so intolerant of other perspectives that we are losing board members who might bring different views, different thoughts to the board? Forceful change to address the signs of an oppressive boardroom dynamic really may be necessary. We've got to avoid it, because otherwise the purpose of board diversity of thought is really lost, and that's super dangerous.
So, Michael, there's a lot going on right now in the broader economy that health industry boards need to keep on their radar. What in your mind are key emerging topics right now that we want to make sure to flag for these autumn board meetings?
Rob, this is number 4 on my list, and I tie it next to the perspective tolerance issue, because what I'm about to say might be the kind of thing that would say, Peregrine, you idiot, what are you bringing that stupid issue in front of the board for? And number 4 is on my list, something that I would never in the world have envisioned at the beginning of the year. But now I see it as an important development that we need to understand and monitor, because healthcare is a highly regulated industry that is dependent in large part on government reimbursement and other funding. And it's the whole thing about what I would call government corporate involvement, or what others call state-sponsored capitalism. It's where we see the federal government seeking to become more involved in the business affairs of companies that get subsidies, grants, reimbursement, or special licenses from the government. So far, it's been manifested through efforts, we've all seen it, to influence leadership selection or tenure, to encourage changes in operational processes or policies, or making direct investment in the company, or other things. We've all read the stories. And I'm not saying it's good, it's bad, or indifferent. I have no idea. All I know is it's important that health industry boards are aware of it. They monitor it, and they prepare a framework of how they would respond should they be in a situation in which they're working with the government, and all of a sudden the government seeks to address a relationship that will allow it to have a greater stake in directing the company's affairs. Is it out from left field? Sure. But we can't say it doesn't exist. And I think it's just something that maybe the strategic planning committee of the board just be aware, monitor it, and kind of anticipate what would happen if we were asked by the government that it take a greater share in how we run our business.
So, Michael, I know we've talked from time to time about the board's role in exercising oversight of AI implementation and utilization. Do you have anything in your top 10 related to AI?
Absolutely. And of course, I think we have slotted to talk about AI oversight as our next podcast series. But a topic with real ascendancy uh, to me is the whole thing about workers who find their jobs assumed by AI or similar technology. The people in the workforce who are, the workforce culture where individual workers are at any level, from the bottom to the top, really worried about whether they're going to lose their job to AI. So, number five on my list is the convergence of governance, human capital, and technology, because I do think that we're seeing that converge more and more. There's a growing recognition that boards have some responsibility to monitor large scale workforce displacement, especially, but not solely, when it's caused by technology. The National Association of Corporate Directors has several white papers that talk about this, and I think they're useful resources. The theme here is that boards of companies that anticipate significant AI use should be encouraged to monitor what its impact is going to be on the stability of the workforce and interrelatedly on its external reputation. Yeah, this is, as we read the news every day, and we're seeing evidence of displacement in both technology and white collar workforces arise. It's not just young coders who are impacted. And I think the board, and certainly Pope Leo has spoken out on this, the board needs to think not only about its fiduciary responsibility, as the NACD has outlined, but perhaps also a little bit about its moral responsibility. What are its values and how are they applied in the context of workforce displacement by technology? What are the responsive measures that a board might take through its management? Worker education, retraining, specialized job placement, but a consistent application of core corporate values. I think it's an issue that's really emerging, Rob, and boards should have some aspect of this on their agenda.
So, Michael, I was just reading in my downtime an interesting post in the D&O Diary about the lasting impact of the whistleblower hotline provisions in Sarbanes-Oxley. Do you have any compliance-related topics in our top 10?
Well, Rob, I'm delighted that you and I read the same outlier publications. Uh, I, I read that post too, and it reminded me that we're kind of losing some of the important corporate responsibility lessons of Sarbanes-Oxley. That was over 20 years ago, but it still it remains important from a variety of perspectives. And number six on my list deals with the issue of hotlines, the hotline concept, the whistleblower outlet that arose out of the concept of Sarbanes. And my focus, for purposes of this top 10, is more about the increasing emphasis on what I call the little things, the compliance minutia. And I'm encouraging my clients to think about efforts to protect their officers and directors and the organization from liability that are associated with, well, have we filled out forms correctly? Have we filled them out completely, internally and externally? Whether it's a conflict of interest questionnaire or some other kind of required internal disclosure, or it's an external disclosure like a tax return, a professional bio, an appraisal form, evaluation, or even a loan application. The whistleblower hotline is a very easy way for concerned employees to report on what they think to be falsification of such forms. And that could have a devastating impact on an officer or director. So number seven on my list is for CLOs to sit down with officers and board members and senior executives and say, hey, look, let's take a lesson from the outside world. We need to be really, really careful. Spend a little extra time on that questionnaire, on that application. You just never know when that may come back to bite you. And even though it may be an unwarranted inquiry, you don't want to go through it.
So, Michael, I know sometimes clients in the healthcare industry view themselves as part of this isolated industry segment rather than as part of the global economy. We mentioned earlier, looking beyond our four walls. Is that something you think boards should be concerned with?
Yeah, I think we have to be, Rob. We learned this a little bit during the COVID era. People remember that. But geopolitical volatility is my number seven on my list. I think most healthcare company boards should have an improved understanding about how global events such as military conflict, tariffs and trade relations, natural disasters, human rights crises, and regime change could impact domestic business operations and supply chains. again, we saw in the COVID area how the supply chains just had extraordinarily critical impact on healthcare institutions. These kind of events can rapidly evolve into tangible enterprise risk for the health system that could require the board to reorient its agenda for a much closer focus on global trends and events. Now, I'm not suggesting that board members or senior management read, international newspapers or global media to search every day, but there really needs to be a recognition of a value and some kind of board awareness that where the organization may actually be implicated by international. Let me just restate that there be impacted by international events or otherwise properly considered as part of the global economy. Where do we get our medications? Where do we get our nurses? Where do we get our researchers? Where are we selling or buying our services to? And I think the answer is, Rob, that a lot of boards will say, yeah, we probably are part of the global economy, and we need to be more alert as an enterprise risk of how things across the globe might affect us. And again, a boardroom visit, I think, from the CFO or the chief technology officer or the supply chain manager might help educate board members on this concept.
Great. I know, Michael, you said a few minutes ago that you had a couple of AI-related items in our top 10. We mentioned workforce disruption. What might be the other?
Well, I think my number 8, Rob, might be a stretch to some. It's what I refer to as the impact of AI self-regulation. I think most of our listeners will recall the recent rollout of the administration's AI action plan. And, the goal of that was to improve the country's competitive status in technology. But part of that plan is to identify and eliminate what the plan calls cumbersome federal or state regulations that could impede private sector AI development. In other words, at least I took it this way, there's probably not going to be any national regulatory scheme as it relates to some of the concerns created by AI, perhaps beyond trust and stuff like that. Prior regulatory proposals in other administrations focused a lot on the irresponsible use of AI and how that could affect societal harm, fraud, discrimination, bias, disinformation, stifle competition, things of that nature. If we're not going to, so they created an awareness of the kinds of risks that could arise from the corporate use of AI. If we're not going to have a formal set of, federal code of regulations governing use of AI, the question is, are healthcare companies going to be kind of on their own in terms of an awareness of the types of harms the company could nevertheless be exposed to in third-party litigation or regulatory intervention or reputation? In other words, I guess what I'm trying to say is there's a potential guidance gap here. If we're not going to have, for better or for worse, a national AI regulatory scheme, or on a state level because of concerns that it would impede AI development, then I think responsible boards are going to want to ask their compliance officers, do we need to come up with our own internal controls? Do we need to look for industry guidance to have a better compliance program with respect to the broad universe of risks associated with AI development? Again, I'm not trying to create a problem where one doesn't exist. I do think it's worth an internal boardroom discussion. What's the impact if we don't have national AI regulation?
So, Michael, in our last podcast, you and I had a fascinating discussion, I think at least to you and me, around fiduciary duty of candor. Does that make your list?
Yeah, it does. It's number 10. And I think, Rob, as we said in our last podcast, board members are going to benefit, I think, from a refresher course on the fiduciary duty of candor. As we talked about, directors can't knowingly lie or omit information when speaking with their fellow directors or to others to whom they owe a duty as to information that's relevant and material to the company. Rob, as you and I talked about, it's really the duty to shoot square with your fellow board members and others to whom you might be in a fiduciary relationship. And as we talked about, and I think it's really important to remind that Delaware case where the court publicly shamed a fiduciary for failing to disclose highly relevant information. I want my board members to know that while this may be a highly unusual remedy, it's out there. And there is something called a candor requirement. And you don't need to worry about monetary penalties if a court has the power to trash your reputation. So I think it's on the list.
And speaking of our corporate reputations, we had discussion in our prior podcast about brand and that being such a core asset that organizations don't want to see impaired right now. Anything that you'd suggest there as far as that being part of our top 10?
Yeah, I think it's really useful. We talked a little bit about this, Rob, back at the beginning of the year in the darkest of winter, but the relations firm Edelman comes out with an annual report on organizational trust, and this year they spoke to the twin concepts of trust and reputation as corporate assets, and I think it's important for board members to realize that these are separate concepts. They're somewhat related, but they are both viewed as assets of the organization. And I think they're intangible assets, but it's important for board members to know how trust and reputation are impacted by issues that confront organizations, issues and the extent to which that the public perceives business, including healthcare organizations, as providing the default solution on issues that the government does not address. In other words, and I don't want to get into a policy gobbledygook, but it's, I think, important that the Edelman survey kind of commends to boards an appreciation for the difference between reputation and risk, what they both mean, how both are earned, preserved, and lost.
So as we come down the home stretch of this podcast, I'm looking for some David Letterman drumsticks to say, let's move to the honorable mention section of this series. What would you add to that list?
Well, you've got the beard, but not quite as long as Letterman does, I think, these days. But there are two topics that, actually, there could be three, that fall into that category for the fall board agenda. First is one that we've had this discussion before. I think it's really for the board to apply some kind of constructive skepticism to proposals aimed at enhancing the mechanism of governance. And by that, I mean stuff like the proposed use of AI to generate meeting minutes, as well as to support governance operations like evaluations, internal controls management, legal and regulatory updates, executive comp, and workforce strategy. I mean, we see many fine companies proposing products that are going to help boards in these areas. And all I'm saying is, let's kind of tap the brakes a little bit on whether that works or not, or whether it creates more problems. It particularly concerns me with respect to using AI to generate meeting minutes and board evaluations. Another honorable mention, Rob, is the new action by the FTC concerning non-competes in the healthcare industry. The FTC chair recently wrote a letter to large healthcare employers, warning them about non-competes and restrictive covenants that could be considered overly restricted. So we've still got that issue, even though there's a change in administration, and it continues to be, it's a compliance risk that needs to be dusted off and reconsidered by the board and its compliance committee. And to that end, very recently, the FTC just announced another situation where it was resolved an overlapping board concern with board members between companies that the FTC viewed as competing. And it's a reminder that, again, in the new administration, the FTC continues to carry over that focus on antitrust prohibitions against individuals serving on boards of competing organizations. So all of those are important, and I think fall into are worthy of an honorable mention listing.
Well, Michael, I'm sad to say that after only 2 games, there is no mention of Notre Dame football anymore in a top 10 or honorable mention list, is there?
Have faith, Rob. Have faith. When do they play Navy and Army and all the junior colleges? Those are still coming up on Notre Dame's schedule.
Well, to our audience, we thank you for always participating with us in these discussions. We'll be back again next month with a discussion of guidelines for board oversight of AI implementation and other ways board may interact with these new technologies that they're being implemented within their organizations. Until then, it's Rob Gerberry and from Michael Peregrine saying thanks again for listening, and go Irish.